Greetings. My name is Ted McClintock. I'm a criminal defense attorney in Colorado, based in Colorado Springs, with over 25 years of experience. Before defending individuals accused of sex offenses, I was a sex offense prosecutor, a team leader of the Special Offender Unit here in Colorado Springs. I've been on both sides of these cases. I've charged them, I've prosecuted them. Now I defend against them. What I'm about to explain comes from decades inside Colorado courtrooms. Not theory, not headlines, and not emotion, but firsthand experience with how these laws are actually applied. Colorado has some of the harshest sexual offense laws in the country, especially when it comes to sexual assaults on children. That in and of itself is not a bad thing. However, the actual application of these laws can sometimes cause grave miscarriages of justice. What most people don't realize is that under Colorado law, touching over clothing can be treated the same as sexual intercourse, the same charge, the same sentencing structure, and in many cases, the same life-altering consequences. This video is not a defense of sexual abuse. It is an explanation of how Colorado law actually works and why the gap between public perception and legal reality matters. Sexual assault on a child, what Colorado law really says. Under Colorado law, a person commits sexual assault on a child if they knowingly subject the child to any sexual contact. And this is where many people are shocked. Sexual contact does not require any sort of penetration, and it includes touching. It includes touching over the clothing. It includes touching breasts, buttocks, or genital areas. It can be direct or indirect touching. Colorado courts have consistently ruled that touching over clothing is legally identical to skin contact for charging purposes. The law does not require force, does not require coercion, does not require prolonged contact. From a legal standpoint, intercourse and over-the-clothes touching are the same. Now, Colorado does have the 4-year age difference. When the alleged victim is under 15 years, Colorado applies that 4-year age difference rule. Here's what that means. A 15 and 16-year-old, there's no offense. A 14-year-old and an 18-year-old, that's sexual assault on a child. The only thing that matters is chronological age. Maturity, not appearance, not behavior, and consent is never a defense. However, if the accused is in a position of trust, everything changes. Sexual assault on a child by one in a position of trust applies when the alleged victim is under 18 and the accused holds any position of trust. There is no 4-year age difference. There is no 4-year age gap requirement. So what is a position of trust? Colorado defines it very broadly. It can include anyone with temporary supervision or authority over a child. There does not need to be a formal title, a job. Even brief or informal supervision can qualify. That makes this determination very fact-specific, very expansive, and extremely dangerous, especially in teenage and young adult relationships. The touching versus intercourse discussion is further complicated by the possible sentences and sentencing enhancers that are applied in Colorado. Touching over clothing is sexual assault on a child. Intercourse is sexual assault on a child. Both fall under Colorado's indeterminate sentencing scheme. That means that a person can receive a minimum sentence with a maximum of life in prison, even when the allegation involves over-the-clothes touching. The minimum allowed is 10 years to life probation. The maximum is life in prison. Another factor is the pattern of abuse enhancer. One of the least understood and most devastating provisions in Colorado law is the pattern of abuse. Any sexual contact happens more than once even if it's the same type of touching, even if it's over clothing, even if it occurs in what appears to be a consensual relationship, the penalty becomes mandatory. 8 years to life in prison. No chance for probation. The judge cannot give probation even if they think it is appropriate under the circumstances. Once a pattern is found, there is no discretion to sentence below that minimum. None. A teenager or young adult who engages in repeated kissing with over-the-clothes touching can, under Colorado law, be sentenced the same as a serial child predator. I once represented a young woman who was charged with sexual assault on a child by one in a position of trust. She was 19 years old, and she was a tutor for a 16-year-old boy, which legally placed her in a position of trust. During that time, they developed feelings for one another. Their relationship involved kissing, making out, mutual touching. No force, no coercion, no violence. When the relationship was discovered, she was charged, not only with sexual assault, but with that pattern of abuse. Because the conduct occurred under Colorado law and that it happened more than once, that charge carried a mandatory sentence of 8 years to life in prison and lifetime registration as a sex offender. To me, this raises a serious and uncomfortable question. Is this the type of case that truly belongs on the sex offender registry for life? Does branding this young woman as a lifetime sex offender meaningfully protect the families of Colorado or our community? Or does it dilute the purpose of the registry by equating profoundly different conduct under the same irreversible label? When we fail to distinguish between predatory behavior and youthful consensual relationships that violate technical lines of the law, we risk turning a tool meant for public safety into one of permanent, disproportionate punishment. Is probation a slap on the wrist? Probation is not what people think. In cases where probation is imposed, the public often assumes that means leniency, a slap on the wrist. It doesn't. Probation in these cases lasts 10 years or longer, sometimes for life. It typically includes things like weekly or bi-weekly probation meetings, no ability to travel, no use of the internet or computers, no use of smartphones, restrictions on dating or relationships. They often make everyone you date come meet your probation officer so they can explain your crime. Lifetime sex offender registration, mandatory polygraph, extreme difficulty finding employment or even a place to live as a registered sex offender, treatment that is expensive and lasts for many, many years. Severe restrictions on family contacts to include removal of ability to have any contact with your own children. This is not a second chance. It is lifelong control. Let's discuss another situation. What if I was misled? What if I was lied to? Many times in these cases, the victims lie about their age. There is no defense for being lied to about age. One of the most troubling realities of Colorado law is this. It is not a defense that the minor lied about their age. Let's talk about another scenario, and I've seen this many times. An 18-year-old meets a 14-year-old. She uses an 18-plus dating app to engage. He claims to be 18 or 19, presents a fake ID, drinks, smokes, socializes like an adult, initiates intimacy, meets your family, convinces even them she's of age and age appropriate. But when that relationship is discovered, none of that matters. Colorado law only looks at the actual ages, whether sexual conduct occurred, whether it happened more than once, and whether a position of trust can be argued. The result for these facts? Mandatory 8 years to life in prison, lifetime sex offender registration, A permanent label is a child sex offender. What about the sex offense registry? Who does the registry actually include, and is it protecting the public here in Colorado? When most people hear sex offender, they picture a violent predator, that stranger in a van, a calculated abuser. But Colorado's registry also includes teenagers, young adults, first-time offenders, those misled by their victim, and those who fit the law that are not actual offenders, like my young math tutor I mentioned. These are individuals whose conduct involved no force, coercion, or penetration. That disconnect matters because laws meant to protect children must also be precise, proportional, and honest about who they punish. Colorado's sex assault on a child statutes impose extraordinary consequences for conduct. Most of us do not associate the conduct I've described above with life in prison. Application of the law needs to be honest and appropriate. It should be about ensuring that justice is informed, proportional, and grounded in reality. If you or someone you love is facing allegations of sexual assault on a child in Colorado, early legal intervention is critical. These cases move fast. The stakes are life-changing. I'm Ted McClintock. If you need help, I would be honored to discuss the situation and see if we can make a difference. Thanks for joining me. Please comment and ask questions. I would be happy to discuss this important issue. I appreciate your time. Thank you.